With the rising concerns by the Information Technology and Business Process Association of the Philippines, or IBPAP, of an absence of a data privacy law, Philippine Congress passed Senate Bill No. 2965 and House Bill No. 4115 on June 6, 2012. After consultation with various private organizations, civil societies, and series of public hearings in Manila, Cebu, and Davao, the Implementing Rules and Regulations of Data Privacy Act was signed on August 24, 2016 by former President Pinoy. It took effect on September 9, 2016. The Data Privacy Act of 2012 is the first law in the Philippines that acknowledges the rights of individuals over their personal data and enforcing the responsibilities of entities who process them.
Data Privacy Act is a 21st century law to address 21st century crimes and concerns. It protects the privacy of individuals while ensuring free flow of information to promote innovation and growth. It regulates the collection, recording, organization, storage, updating or modification, retrieval, consultation, use, consolidation, blocking, erasure or destruction of personal data, and ensures that the Philippines complies with international standards set for data protection to National Privacy Commission, or also known as NPC.
Studying BPA is very significant for us student nurses. It will not only enhance our knowledge about the scope and limitations of this act, but will also help us in our future clinical practices, especially in handling information of our patients. In relation to nursing informatics, Section 8 of this act is about confidentiality. As we all know, confidentiality is one of the ethical principles that a nurse should consider as part of the right of a patient and also as part of her duties that we treasure.
Go. As we go along with the topic of Data Privacy Act, we as future nurses and workers in the hospital with technology involved like computer-generated hospital documents. And for us nurses, the electronic medical records will have the progress regarding the skills application and also our attitude towards keeping documented personal information, whether it is written or computerized.
Having said the scope of the DPA, we will also benefit upon knowing the law itself, especially when we are already licensed registered nurses who are capable with decision making and is liable with the information that needs to be protected. A common example is the data of a person with serious illness or a sexually transmitted disease.
Overall, there are lots of importance of Data Privacy Act in relation with informatics and nursing practice because it deals with information that needs to be documented. As we all know, what is documented will always be considered as legal, especially when it is countersigned by the nurse involved and when there are problems that may occur. As long as you know about the Data Privacy Act, you can always be protected.
The most common patient confidentiality breaches fall into two categories. The first one is the healthcare workers' mistakes, and the second one is the unsecured access to protected health information, or the PHI. In the US, a law was designed to provide privacy standards to protect the patient's medical records and other health information. The list of common privacy breach are the following: keeping of unsecured records, unencrypted data, hacking, loss or theft of devices, lack of employee training, gossiping or sharing of the protected health information, employee dishonesty, improper disposal of records, unauthorized release of information, and also a third-party disclosure of the protected health information.
In the event wherein there could be a breach of privacy, the possible scenarios could be loss of hard copy notes, USB drives, computers, or mobile devices. or an unauthorized person gaining access to a laptop or computer, access to an email account or computer network, and also sending an email with personal data to the wrong person. These examples are some of which privacy is breached.
In the nursing field, this could also happen. An example of this scenario is if a coworker is discussing with a patient with you and you don't have a professional reason to know about the case, remind them that the patient confidentiality laws are in play and they should stop discussing the patient with you.
Another example scenario is when an information is left lying in a trash can or in a computer's recent file folder. It could get into the hands of the wrong person. Same goes with leaving page ID data vulnerable without putting an encryption or leaving data files on a desk or in a filing cabinet that is left unlocked.
Nurses deal with patient private information all day, every day, from nursing stations and offices, to exam rooms, to patient bedsides, to operating rooms. Being a student nurse exposed to clinical duties, I have witnessed how they strictly perform security measures to protect patients' information.
Nurses being compliant with Data Privacy Act of 2012. Nurses speak quietly when discussing patient information with colleagues or a patient's family, especially in a public area. Patients' health information is monitored and disclosed only to doctors, nurses, and other workers that provide healthcare to the patient. The important information including are demographic information, health conditions, including diagnosis and test results, clinical data such as lab results, diagnostic test results, procedures, medications, billing information, and photographs. Also, nurses value patients' confidentiality to show moral respect and retain the important bond of trust between them.
Nurses reveal information for legal requirements to authorities for suspected child abuse, reporting cause of death, and information of the spread of certain infectious diseases, including COVID-19. Nurses reveal important medical records with appropriate guardians if the child is minor or adults that require an intensive care. Withholding pertinent information if could predispose harm to the patient.
There are a lot of advantages of using informatics in relation to protecting the patient's information. And one of them is that there is a law, which is the Data Privacy Act, which protects every information of the patient, and it is not disclosed to anyone. This act protects the patients from anyone who discloses their information, whether it is sensitive or not, in a public space or even to the friends and families of the healthcare providers. Patients could also file a complaint to anyone who discusses their condition or information to anyone. Therefore, through this act, healthcare providers would certainly keep all information confidential.
There are also rights of data subjects, which is an advantage of informatics, such as right to information, right to object, right to access, right to correct, right to erase, right to damage, right to data portability, and right to file complaint. Note that the technology have improved the way healthcare workers do their job, and it also improved the way information are kept and secured which protects patients. Also, through informatics, patients could have access to their own records, which are secured and can only be accessed by authorized personnel.
Yes.
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 The need to maintain the confidentiality and security of personal information has become critical in this age of social media. Facts and figures which can be both true and fake can be sent to their intended recipients with practically no liability and accountability. Personal data is an essential element of human rights and should therefore be treated with the utmost care and security by whoever is given the authority to collect and process them.
This was supported by Antonio, Patdu, Marcelo in their systematic review, Trends and Challenges in Policy and Practice, Privacy in Developing World, Philippine Monograph Series. The study revealed that the Philippine law jurisprudence recognize and protect privacy of health information as a general rule, and that a privacy culture on either the provider's or client's side is also lacking in the country.
Like St. Luke's Medical Center, they have these guidelines like Data Privacy Notice, in which commitment to uphold privacy of patients and clients is their priority, and that the protection and confidentiality of patients' personal data are their ultimate concerns in order to be consistent with the requirements of Data Privacy Act of 2012, its implementing rules and regulations, National Privacy Commission issuances, and other relevant laws.
As for our observation in terms of collection and processing of health information, our Philippine healthcare system have been implementing this to all the healthcare institutions. According to the Philippine Health Insurance Corporation Joint Administrative Order number 2016-0002 entitled Privacy Guidelines for the Implementation of the Philippine Health Information Exchange. This code is hereby promulgated to prescribe the procedures and guidelines that ensure the protection of the privacy of a patient. And one of these is the consent we give to our patients when giving their information, especially for medical purposes.
Over the past years, there are innovations like the use of technology that help our healthcare providers for easy access to information database about our patients and make it possible for a virtual patient consultations and specialist referrals involving parties separated by physical distance. The development of electronic medical records, or EMR, transcends the physical limitations of paper files and presumably facilitates access to and sharing of health information among providers of care, improves the accuracy and quality of recorded data, and, more important, improves the quality of care as a result of having health information immediately available at all times for patient care.
The Philippines set the gateway of changing health information landscape. The shift towards the use of health information technology has been a global trend. The impact of these changes on traditional notions of privacy and confidentiality between the health provider and the patient is a challenge. Therefore, using health information technology and telemedicine and storing patient data in electronic form all amplify the privacy issues in the context of the relationship between the health provider and the patient.
The tradition of privacy and confidentiality within the context of patient care is attributed to Hippocrates of Kos around the 4th century BC, when he admonished his followers, "All that may come to my knowledge, in exercise of my profession, or in daily commerce with men, which ought not to be spread abroad, I will keep secret and will never reveal." The duty of confidentiality for healthcare providers and the rights of patients to privacy are uncontested and universally recognized.